This is Barry Zelma speaking for Claim School Incorporated's blog, Zelma on Insurance. Today, wearing a hat because I've received complaints that I didn't wear my hat. We speak about what happens when there is overwhelming evidence to establish the guilt of a person who commits fraud, including workers' compensation fraud, and why a witness's statement, rejected and the subject of an instruction by the court to ignore it, is not prejudicial and is not a violation of the 14th Amendment. A jury convicted Adan Contreras Rivas of several felonies, including theft by false pretenses. On appeal, Rivas argued he was denied his right to a fair trial under the federal Constitution because a prosecution witness briefly mentioned that Rivas had been previously arrested. In the case called the People v. Adan Contreras Rivas, the California Court of Appeals on March 7, 2024, dealt with the constitutional issue raised by a fraud perpetrated. Between 2020 and 2022, Rivas agreed to perform landscaping projects for various homeowners but failed to complete the work. The prosecution charged him with 5 counts of theft by false pretenses, 4 counts of contracting without a license, and failure to obtain workers' compensation insurance. The prosecution also alleged several enhancements, including a prior theft-related term of imprisonment and prior convictions for contracting without a license. After being hired and completing gardening projects, Rivas would then offer to perform larger projects, including landscaping their yards, building a fence, and constructing patio structures. After the homeowners agreed, Rivas asked for advance payments, which the homeowners paid. For a few days afterwards, Rivas would send workers to perform discrete portions of the project, such as demolition or digging, before completely abandoning the project. Rivas then ignored later attempts by the homeowners to contact him and failed to provide them with requested funds. A special investigator determined that from January 1, 2019 until July 13, 2022, Rivas did not possess a contractor's license, and from November 29, 2020 through July of 2022, he did not carry workers' compensation insurance. The jury convicted Rivas on all charges. The trial court then found that the enhancements true and sentenced him to state prison. Before trial, defense counsel moved to exclude Rivas's prior convictions and to bifurcate the prior convictions and special allegations. The trial court granted the motion and issued an order in limine to stop people from mentioning them. At trial, however, one of the homeowners testified that he stopped asking Rivas for a refund when he and his wife came to know Rivas's real name and learned that he had been previously arrested. At this point, both counsel interrupted and defense counsel objected. The trial court asked if defense counsel would like an order to strike, and when defense counsel indicated he would, the court struck the last portion of the witness's answer and instructed the jury not to consider it. The trial court, denying a motion for non-suit, noted it had previously instructed the jury that the fact that Rivas had been arrested, charged with a crime, or brought to trial was not evidence of guilt, an instruction it would repeat in the final jury instruction. Thus, the trial court concluded no material prejudice had occurred. Rivas's sole claim on appeal is that the prosecution witness's fleeting reference to Rivas's previous arrest was extremely prejudicial and denied him his right to a fair trial under the federal Constitution. The Court of Appeals noted that the 14th Amendment to the federal Constitution prohibits states from denying any person due process of law, and where an appellant asserts evidence was erroneously admitted, this standard can only be met where there are no possible inferences the jury may draw from the evidence, and the evidence is of such quality as necessarily prevents a fair trial. The Court of Appeals concluded that no error occurred that rendered Rivas's trials fundamentally unfair. Notably, the testimony that Rivas had been previously arrested was never admitted into evidence. In fact, the moment the witness mentioned an arrest, the prosecutor immediately interjected, defense counsel objected, and the comment was stricken from the record. Under these circumstances, as observed by the trial court, it is unclear if the jury even heard the word arrest. But even if the jury had heard the word arrest, and it had not been stricken, permissible inferences could have been drawn, and the evidence was not of such quality as necessarily prevented a fair trial. After striking the statement, the trial court immediately admonished and later re-instructed the jury to not consider it. It is well established, the Court of Appeal noted, and Rivas does not dispute that fact, that a jury is presumed to have followed an admonition to disregard improper evidence, particularly where there is an absence of bad faith. The Court of Appeals concluded that the evidence of Rivas's guilt was overwhelming. The fleeting reference to a previous arrest was non-prejudicial and did not result in a due process violation. Rivas was not deprived of his constitutional right to a fair trial, and because the evidence of Rivas's guilt was overwhelming, the Court of Appeal concluded it was not reasonably probable that he would have obtained a better verdict in the absence of the witness's brief and vague mention of a previous arrest, and therefore the judgment was affirmed. In my opinion, this is another case where I am amazed that a defendant faced with the claims of different types of fraud, including insurance fraud, have the wherewithal and funds to file spurious appeals over such a minimal fact situation in a hope that the court would ignore the evidence that established the guilt of the defendant. The Court of Appeal took Rivas's claims seriously and disposed of it when it should have just dismissed the appeal without comment. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog and the videos as well. If you click on the URL, you'll be provided with a link to subscribe, and then you'll be given notice of every blog posting, usually 5, sometimes 6 a week, and you will also be allowed access to the more than 4,750 blog postings. If you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.